Go. In CPLR 213, action based upon fraud, generally you have 6 years for your statute of limitations. 6. But if you can get 2 years from the date of discovery or from the date of when it reasonably would have been discovered. So either 6 years or 2 years from discovery, 2, or 2 years from when it reasonably could have been discovered, 2.
Certain actions to be commenced within 3 years of discovery. In this section, exposure means direct or indirect exposure by absorption, contact, ingestion, inhalation, implantation, or injection. Notwithstanding the provisions of 214, the 3-year period within which an action to recover damages for personal injury or injury to property caused by the latent effects of exposure to any substance or combination of substances in any form upon or within the body or upon or within property must be commenced, shall be computed from the date of discovery of the injury by the plaintiff or from the date of imputed discovery, whichever is first. 3. Whenever a general, special, local law or charter requires as a condition precedent a notice of claim be filed or presented within a specified period of time, this section shall not apply to any action for medical or dental malpractice. And the reason for that is because there's constantly medical and dental knowledge being discovered all the time. So you couldn't possibly hold a doctor responsible for medical malpractice if there just wasn't the knowledge there to be known. But if a company knew that they were poisoning something and there just wasn't the scientific evidence there to prove it back when you first got injured from it, they should be held responsible if you can now prove it. So that's why this statute is giving you an extra year from discovery of the cause, an extra year from discovery of the cause of the injury. But it doesn't apply to med mals or dental malpractice.
Action to recover damages resulting from exposure to Agent Orange. Agent Orange is 2 years from the date of discovery. Agent Orange, 2 years.
Go. 215, actions to be commenced within 1 year. Now there's the standard things that are in this section that have to be commenced within 1 year, which is actions against the sheriff, coroner, constable, for an escaped prisoner, assault, battery, libel, slander, false imprisonment, malicious prosecution, violation of a right to privacy.
1 year, an action upon an arbitration award. 1 year, an action to recover any overcharge of interest or to enforce a penalty of such overcharge. 1 year, an action by a tenant pursuant to subdivision 3 of section 223 of the real property law. 1 year, whenever it is shown that a criminal action against the same defendant has been commenced with respect to the event or occurrence from which a claim governed by the section arises, the plaintiff shall have at least 1 year from the termination of the criminal action. The plaintiff shall have at least 1 year from the termination of the criminal action as defined in section 1.20 of the criminal procedure law in which to commence the criminal action, notwithstanding that the time in which to commence such action has already expired or has less than a year remaining. That's it.
Any of those items, if there's a criminal action that's commenced regarding those things, then you get an additional 1 year from the termination of that criminal action. So whenever it is shown that a criminal action against that defendant has been commenced with respect to those 1 year items, then the plaintiff shall have at least 1 year from the termination of the criminal action. Accrue interest on an order that directs the payment of money that's docketed like a money judgment from the date of docketing. So there's two different things. It's either from when it's entered or when it's docketed. Money judgments, when they're entered. Orders directing the payment of money that are docketed like a money judgment from docketing.
5002, interest shall be recovered from verdict to the date of entry of judgment and shall be computed by the clerk. Note there are 3 general time periods for the calculation of interest. 1, the date of occurrence to date of decision or verdict. 2, date of decision or verdict to date of entry of judgment. 3, date of entry of judgment to date of payment. Shall bear interest from the date of its entry.
And then
Wait a
the
minute,
follow-up.
and they said money judgment, date of entry.
Yeah.
Yes, but the other thing is if it's a, well, no, you don't have to add me to that thing. But I'm saying that's where I got tripped up because there's one thing where it's not less than 30 days.
Not less than 30 days. And then the 45 days is the guy with the 10 years.
the DA has 45 days to, I guess, object.
Yeah, 45 days to object. The other one, I don't think has to do with objecting. That's just for them to be able to submit.
To comment. That's the thing that everyone throws in the
materials.
garbage.
Yeah. So that's 30 days. Objection, 45 days.